Joining
Or
us.
not.
Good morning, everyone. Thanks for joining us this morning for our webinar, the turnover event, transitioning from unit owner to developer control. My name is Jen Barnett, and with me is my partner, Tom Aylesworth. We've both been with MEEB for quite some time, and we're very familiar with this area of law. It can be overwhelming. An overwhelming time in the overall life of a condominium. And we're happy to provide you a little bit of guidance to the extent, this morning, and we're happy to answer any questions at the end of our webinar. There's a lot to cover, and we're not going to cover, everything there is to know, but hopefully we'll give you a good framework to work off of. And unless, Tom has anything else to say, then we'll get started.
Just good morning, everyone. Thanks for joining us. We're excited to present this information to you. It's not unusual for us to get calls from board members or property managers concerning transition issues, and it's a really important topic, and we're really pleased to be talking to you about it today. I'm going to switch to the screen share, and we've got a PowerPoint presentation for you, and you can follow along. And Jen, you can see the PowerPoint? Yes.
Yes.
Okay, take it away, Jen Barnett.
All right, thank you. So when does turnover occur? So the turnover is the event that is essentially the transition from the developer control over the association, the board, back to unit owner control. In Massachusetts, the deadline is set in the condominium's governing documents. Unfortunately, in Massachusetts, there is no statutory deadline for the turnover. Oftentimes, a developer will retain control over the association until most, if not all, of the units are sold, or for a period of years. Especially in the case of phased developments, they want to hold on to that development rights, which we'll get into later. And there's, in some instances, a developer will hold on. The governing documents will say that the developer is going to hold on until all phases are sold. Sometimes, if the economy is good, this works out. Other times, the issue is that the project will get stalled out at some point. What I mean by that is, example, there's 5 phases of contemplated phases of a project. First 2 get built right away. This third is a little slower. And then time passes. We're going on 5 years, 10 years. At some point, an argument can be made that the marketing phase of the project's over. By that, the developer is no longer building, the developer is no longer selling, seeking to actively market and sell units for sale. And at that point, the unit owners, if that occurs, the unit owners may want to push for the turnover to happen, because the turnover triggers, basically the association takes back ownership of the association, establishes its own budget, determines what might be missing from the budget, and it's important that you don't let the developer hold on longer than allowed. And if it comes a time where it's just stagnant, it's time for the developer or unit owners to take action. In New Hampshire and Rhode Island, the turnover event is controlled by the statute. So with a traditional condominium, it's 2 years from the creation, which is the recording of the declaration, or the sale of 60% units have been sold, whichever event comes first. With convertible land, that's a phased condominium. It's 3 years from the creation, again, the recording of the declaration, or 60% of units have been sold, or 2 years after units have last been marketed for sale, or 2 years after the development rights were last exercised. So that's similar to the marketing phase of the project that in Massachusetts. In expandable land, this is again a phased and adding land 5 years from the creation report, i.e. the recording of the declaration, or 60% of units have been sold, or 2 years after units have been marketed for sale or the development rights were last exercised. Again, whichever comes first. In both New Hampshire and Rhode Island, and associations governing documents can provide for a lesser period of time for turnover, but cannot extend it beyond the time allowed under the statute. In the turnover in New Hampshire, so like as I mentioned, the most important thing that the turnover event is taking control over the board that operates and manages the association. So unfortunately, Massachusetts does not have a protocol or a framework for putting unit owners on the board during this transition event. In New Hampshire, however, their statute is newer, and they have developed a protocol for this process. So in New Hampshire, the Condo Act requires that unit owner be allowed to participate on a declarant-controlled board during that period, shortly before transition. After 1/4 of all units have been created, that may be created, have been sold, at least one member, and not less than 25% of the board, must be elected by unit owners other than the declarant. After at least half of the units that may be created have been sold, at that point, at least 50% of the board must be elected by unit owners other than the declarant. And this is great because it helps with the transition. It gives the unit owners who are serving on the board this is all in theory, a better understanding of the processes and procedures. I say in theory because Tom and I wouldn't be involved if everything went smoothly. So there are many times the developer, when they put the unit owner on, they'll still be friendly to the developer. They'll still be they could be associated with the developer somehow if they're a unit owner, because at this point, unit owners can still be a developer related entity, could in fact still be a unit owner if they hold title to any of the units. In Rhode Island, the declarant control terminates upon the earlier happening of either 60 days after the conveyance of 80% of units to third parties, 2 years after the declarant has ceased to offer units for sale in the ordinary course of business. Again, this is similar to the marketing phase of the project that I mentioned in Massachusetts. And the third trigger is 2 years after the development right to add new units was last exercised. And like New Hampshire, the association's documents can provide a shorter period of time for this to happen, this turnover to happen, but cannot extend beyond the statutory limits. So like New Hampshire, there are rules in Rhode Island for unit owner participation on the declarant controlled board before turnover. In Rhode Island, it's after 25% of units that could be created. Our board must have at least one unit owner, not less than 25% of the entire board has to be elected by unit owners other than the declarant. After the sale of 50% of units, again, to be created, the board must have at least 1/3 of its members elected by unit owners other than the declarant. Following the transition event, the unit owner shall elect at least 3 members, board a majority, whom shall be unit owners. But as I just mentioned, if the declarant still owns units, they are an eligible unit owner for purposes of a seat on the board following the transition. So of course, why is turnover? Why is this important? Because control is power. It's power over the association. It's power to make decisions on the operation management. Many times you'll find that a developer will have the construction company will be a developer related entity. The management company might be a development related entity. And so the unit owners and residents living in these associations have very little opportunity to be heard, voice any objections. And these are people's homes. And so they should have a right to a say and a seat at the table as to how things are operated and managed. In what early turnover to prevent developer abuse. This is again, sometimes developers hold on too long in doing this. They let the statute of limitations for potential claims run. They could squander assets of the association. By that, I mean, they may, a lot of times when Tom and I see them, I'm not saying every time I'm saying, but frequently what Tom and I have seen is they won't properly budget, manage long-term. They think in the short term, how can I make this association as appealing as possible to third-party purchasers? A lot of times these developers will be single purpose entities. So if they're developing a property at 10 Main Street, they might be the 10 Main Street LLC. And once that last unit is sold, they may not have other assets, but to recover against if there were to be a claim. And, sometimes there's negligence when there's negligence claims, there might be insurance coverage, but the idea is you don't want to achieve a Pyrrhic victory. Why that I mean, if you find out you have $1 million in defects and the developer doesn't have any assets, it's even if you win a trial, it's not going to mean anything because you're not going to be able to recover. So the election is important even in those states that have the requirements for a unit owner to be appointed to the board. Sometimes, and I'm saying, when I say sometimes, I'm saying when I mean these developers, obviously there's good developers and there's developers out there that are going to do everything by the book and not going to have any issues. That's not what Tom and I are experienced and dealing with. We often, we do represent developers and we try to make sure that they do not find themselves in these situations. However, we often are on the other side where the developer has not done everything properly. And that's why, and Tom and I are involved in the litigation aspect. So there's potential for a developer to try to, solicit support right before an election to, developer friendly appointees. By that, they could try to stack the election with people, friends of the developer who own units or, family members. There's also potential for them, if too many candidates are running, it can dilute the percentage required to obtain a majority for purposes of the election. So, if there's a group of unit owners that, a pre-transition committee that it can be up and running, that might be a way to get ahead of the developer attempts to, unduly influence the election. So there's, unfortunately, once that election happens and, there's certain requirements, every association is different as to when the appointment is effective. Most documents require that the appointment becomes effective upon the recording of a trustee certificate of appointment. It's an acceptance. But regardless, once that transition happens, there really is no grace period to get up and running. The board is going to have to take responsibility, take ownership of its role, understand what its role is, and advanced planning is incredibly important here. We do have a developer checklist that we'd like to give to our clients, and we'll send that around after our webinar today. But there's a myriad of tasks to do, and it could, like I said at the outset, this can be overwhelming if you're not prepared and you don't understand the process ahead of time. Even with proper planning, it can be tedious, but it's essential. In terms of prioritizing tasks, there might be long-term goals and things that the association wants to do. These can be, going more green or doing long-term, achieving long-term objectives. That's not what you should focus on at the time of the transition. At the time of the transition, you have to understand that you're up against a very finite window by which you can act if there are any issues. So you want to address if you know that there's safety issues, if you know that things weren't done properly, don't delay. And if you are going to, this is the time to get a handle on the financials, the operational aspects of what contracts do you have outstanding. Are they developer friendly contracts? Are there construction defects? For example, if you know the binder code of a road is in place, but the final seal code has not been applied, that needs to be addressed before the developer sells off his last asset. This might be a good idea, and we'll get into this, to start even before this, to start thinking about whether or not you're going to need to do a transition study. If there's obvious defects or deficiencies, or water's already leaking, A, don't sign any releases, and B, don't wait to take action. And it's not going to, I wouldn't rely entirely on the developer to fix things at this, this is the end stage. This is when they're winding up and trying to get out. So don't let things, don't hope for the best. It's not, you can trust, but it's necessary to verify. Financial red flags. So looking at just the financials, and you can look and see, are the condo fees too low? Sometimes developers will set fees artificially low to entice buyers to purchase into the building in order to be association. And once that transition event occurs, you find out that these, your fees aren't necessarily covering everything, because perhaps the developer was supplementing, for example, operating a pool, or they were they were providing their own snow removal especially if they're also affiliated with the construction company. And so these are all things that the association, once turnover happens, is going to have to deal with. So the other big red flag, and this is actually not that difficult to determine, is, did the developer assess each unit for its pro rata share of condo, monthly maintenance fees from the date of creation to the date of sale? So many times, one of the biggest issues we've seen is in this terms of financial overview is that a developer won't pay, their condo fees on a unit won't be paid until the first time that they're sold off. So this could be, a period of months, it could be a period of years, and these add up. And so if for example, the developer is selling off these in blocks, and there's 10 units that haven't paid their a pro rata share for a year, that's a significant chunk of money. The other issue that we see is, the developer use common expenses to pay for developer related expenses. So is the developer paying for sidewalks out of the common expenses? Does the developer pay for paving out of the common expenses. Those are developer related expenses. Those are not expenses of the association. And it's important to understand the difference when, looking at the financials, because that can be another issue that the developer should be expected to reimburse the association on. Sometimes the developer will come back and say, well, I lent the association X, Y, and Z. But the flip side of that is that they shouldn't have, because they should have budgeted properly. And that goes into working capital and reserves. Especially on these phase developments, the first phase can be 10 years old by the time that the final unit's sold off. So they're coming up to they could be at the end of their useful life for roofs or for other capital, maintenance items. And if there's not money to fund those, that's going to be an issue. And, another point to think about is the contracts. As I mentioned earlier, is it, is the developer somehow connected to the management company, the construction company, the snow removal company, and are these adhesion contracts? And by that I mean, are they blanket contracts that say these are binding the association in perpetuity, and we have very difficult cancellation provisions? In Rhode Island and New Hampshire, you can avoid developer-friendly contracts. Massachusetts, it's a little bit more difficult. The trend seems to be going in that direction, but we don't have very, it's not as clear cut, I would say, as it is in Rhode Island, and New Hampshire. The other thing to think about is insurance adequate. So special coverages or coverages required by documents. It's always a good idea to have your documents reviewed on at least an annual basis by an insurance agent, just to make sure you have adequate coverage. Many times, again, insurance you'll find is very expensive, and the developers are going, many times, again, I don't want to say always, but many times a developer will not obtain the broadest coverage possible, and sometimes they might not even obtain the coverage that's required in the documents. The one thing to consider is it's called law and ordinance coverage, and so again, this is for the phased units or the phased developments that are spread out. Law and ordinance coverage is that upgrade coverage. So if you have coverage that was, to replace something 10 years ago, that might not be the same coverage as it would be now if it doesn't incorporate the necessary quote upgrades. The other thing is assessment coverage. So if there were to be some sort of assessment, this would cover the gap between because of insurance shortfall, this would cover that. The assessment coverage would provide that coverage for that special assessment or temporary fee increase to however it is determined. That also is important to determine if there's that assessment coverage. That would be something though that the unit owners would purchase separately if the documents called for it. But these are all important things to consider. Insurance, you'll find, is very, very important. Also consider, is there pending litigation? Is there already a fight between the developer and a abutter about land? Is there, are there already issues regarding potential claims related to easements, adverse possessions, any insurance pending insurance claims? How are those going to be handled? Who's going to be who's the insured, who's the beneficiary under those policies? These are all things to think about at the time of transition. So I mentioned earlier, one of the things to consider related to the operation of management is to recover those unpaid condo fees. So if there's if their developer used common expenses to fund the development of the condominium, that should be subject of a demand to get back. If the developer didn't assess and collect condo fees while they were in control of the association, that might be a claim for to recover. And you'll find that if the developer still owns a unit and it hasn't been paying, that it would be, this is a really important time to pursue a claim for unpaid condo fees, given that priority. Lien, that we can speak on a whole other webinar on that, about the benefits of asserting a lien enforcement action, or pursuing a lien enforcement action against a delinquent developer. But at least it gives it's an asset by which to recover, or potentially recover, if there are unpaid common expenses. Breach of fiduciary duty, this is, again, if they didn't assess and collect while they were in control of the association, this goes directly to their fiduciary duty. And did they, are they paying an exorbitant management fee to their developer associated management company? These are all things to consider. A successful claim might allow the recovery of attorney's fees under what's called the Consumer Protection Act. It's 93A in Massachusetts. It's referred to separately in New Hampshire and Rhode Island, but the gist is that the developer was engaged in a business. The developer owed a duty to the association, and every unit owner who purchases in to this scheme is relying on the developer to properly manage the assets and to not squander funds for its own benefit. So the transition team, as I mentioned earlier, the slate of having a slate in place before this, the election actually happens, a few months at least before the anticipated turnover, unit owners should start to think about the transition event. And it's a team. I don't know sports, so I'll try not to make any sports references that don't make sense, but you want to start building, your roster. You want a lawyer because you want them to really give you a sense of what the claims are, potentially, to look at the documents, including any amendments. Was there any, for example, I had a situation where the developer, while they were in control, tried to unilaterally amend the documents to extend the development rights, and they ended up trying to withdraw. Actually, they withdrew land, a part of the land on paper, an entire lot, and then they sold it to a third party. And this was done through a quote unquote amendment. We had to actually go to court and unwind all of this and void the transfer, and because the amendment wasn't valid. So just because it's one of those, just because it's on the internet, just because it's on the registry, doesn't mean it's necessarily valid. So this is look for leverage. What's the status of the development rights? What are the status of are the development rights are about to expire, which we'll get into in a bit. But these are all things that you would want an attorney to look at before you get to the turnover event actually happening. A manager, you want to start interviewing managers before the transition. They will help. Especially an experienced manager can help walk through this process, can coordinate, vendors can coordinate, engineers to conduct a survey. An engineer will come in, especially if you know that there are issues. An engineer is critical here to do a thorough walkthrough, investigation. They will develop, they can prepare a transition report, which basically will identify the defects and deficiencies. If you take one thing away from this webinar today, please do not share this transition report outside of the board, because once it's privileged as being done in anticipation of litigation. We prefer that this be coordinated through the lawyer to give it that extra privilege as well as an attorney-client privilege. But if it's so essential that this preliminary report does not go outside the board. It's because it is preliminary in nature. There's ways to express the information that's contained within the report without sharing the actual report. But I just cannot emphasize enough, and I'm sure Tom will get into this as well, that don't share that report outside of people on the board. And even if there's not defects or deficiencies, they might help to prepare a reserve study. So that means they can explain what the expected lifetime or useful life on a roof, roadways, other infrastructures to assist the new board in long-term planning. And with that, I will turn it over to Tom.
Thanks, Jen. So I'm going to spend a little time talking about construction defects. Maybe not everyone's favorite thing to consider right after the transition from the developer to the unit owner controlled board. However, it is something that is really not an option as far as a key consideration when the transition occurs. And the reason is there's a couple of reasons for that. One is that, of course, right at the transition time, typically the developer is still involved in some way, oftentimes has more units to build or has more units to sell. Also, in many cases, the developer is a single purpose entity that was created solely for the purpose of creating the condominium and selling units. And it's not unheard of for these single purpose entities to stop operating after the units are sold. So strike while the iron is hot. Also, and perhaps more importantly, I'm going to talk about in a minute, construction defects is a subject, or it's an issue that has to be addressed right away during the transition, because if there are defects, you will be faced with statutes of limitations on the time in which you can bring a claim. So it's important to consider construction defects right away during the transition. So to begin with, many condominiums will have some type of construction defect. And, in most cases, the defects are fairly simple to correct. And it's not unusual for the developer to cooperate, what we would call punch list items, trim or small kinds of issues to the exterior or to common areas. And the developers typically will be fairly cooperative in trying to fix simple issues. And I would say in most cases, that's what these defects are. They don't really go to the level of being serious defects. I'll say as an aside, when we talk about construction defects in communicating with our clients, the boards and the property managers for the most part, sometimes developers, we're talking about defects to common areas, not the units themselves. If there is a problem with a unit, with the construction of a unit, that is an issue between the unit owner and the developer. If there is a widespread defect to the construction of units, let's say all of the flooring is bad in every unit or most of the units, there have been cases in which we've had the board try to address those issues with the developer, because it makes sense, just more efficient to do so. If it gets to the point where it requires or it ends up in court, the unit owners can assign their claims for unit defects to the board to pursue, just because it makes it more efficient. But for the most part, what we're talking about here are defects to common areas. Like I said, for the most part, they're fairly routine and not too severe, but we do get cases where there are serious construction defects. So The point is that your condominium association, you're going to have to fix the defects. And that means you have to pay for it. Of course, the goal is to try to work with the developer to minimize the cost or eliminate the cost to the condominium association. After all, it's the developer who's responsible to fix the problem. In practice, it can become a very difficult issue to negotiate with developers, of course, depending on the severity of the defect, and depending on how responsible the developer wants to be. As I mentioned, there are statutes of limitations that have to be kept in mind if it gets to the point where a legal claim is being considered. I tell all my clients that really when you're looking at construction defects, litigation is a last resort. And the reason is because it's expensive and it's time consuming. If the issues can be resolved with the developer without having to go to court, that is the goal. And we work very hard to try to make that happen. But when that doesn't work, we have to keep in mind that filing a lawsuit comes with time limits. In Massachusetts, it's 3 years from the date that the board knows or should have known that there's a problem. It's also 3 years in New Hampshire and 3 years in Rhode Island. So for all 3 states, you have 3 years from the date you know or should have known. Now, those time limits can be told, meaning they can be extended. Number one, if it's a concealed defect. For example, I had a case in which there was a defect to the roofs on multiple condominium buildings. The defect wasn't obvious because it was enclosed attic spaces that nobody could access. And so we were able to bring a claim after the 3-year statute of limitation because it was discovered. It was discovered after 3 years had passed, and it was concealed. And so that was allowed. We could bring the claim after 3 years. And of course, there are other issues that arise. For example, sometimes the developers actually hide or conceal defects, or they make representations that they've taken care of defects during, while the process of finishing the condominium is underway. That can also extend the 3-year statute of limitations. And then there's the somewhat murky question about what happens when the defect is obvious and everyone can see it. For example, another case I had in which a roof was severely sagging, and then the transition occurs. What happens, for example, in Massachusetts, where a developer has been building a condominium for 10 years, and the transition happens in 10 years, and there's defects that have been around for 5-6 years? That's a murky question. It's one that there's no clear answer for, because it creates sort of an unjust situation. One theory is that unit owners actually have an obligation, or they're required to make a demand on the developer to fix defects even before the transition. So if you are involved in a condominium where there's an obvious defect, even before the transition, the best practice is to make a demand before the transition so that you don't run into a potential statute of limitations problem. Then that leads us to the next limitation period, which is the statute of repose. And all 3 states have them. It's 6 years in Massachusetts, 8 years in New Hampshire, and 10 years in Rhode Island. And it's basically those time limits in general, speaking in broad terms. from the date that the condominium is substantially completed. Now, what is a statute of repose? So even though you have 3 years from the day you know or should have known about a defect to file a lawsuit, there is an outside limit, there is a ceiling. For example, in Massachusetts, after 6 years from the date that the condominium is substantially completed, you're done. You have no right and no ability to sue the developer for construction defects, regardless of when you discover them. So if 6 years have passed, or 8 years in New Hampshire, or 10 years in Rhode Island, there's no right to recover against the developer. And what this means is, for example, if let's take New Hampshire, and you have 8 years to bring a lawsuit from the date that the condominium is substantially completed. Let's say you discover the claim after 6 years. Does that mean that you have 3 years under the statute of limitations to bring a claim against the developer? The answer is no. You only have 2 years because of the 8-year statute of repose. So the statute of repose, again, those are outside limits. They cannot be extended. They cannot be tolled. They're hard deadlines. And once those deadlines pass, there's no ability to recover against the developer. There's a question that comes up not infrequently. What happens for phased condominiums? What if there's more than one building, for example? We know the answer in Massachusetts in any event from a decision that was issued by the courts a couple of years ago, and the court did confirm in Massachusetts, the Massachusetts Supreme Judicial Court did rule that the statute of repose can be different building by building. So if your condominium has 6 buildings, as each building finishes, then the statute of repose, the clock starts ticking just for that building. And that can be helpful, particularly when buildings are added to condominiums over many years, which we do see happen. So those are the deadlines that have to be considered when thinking about legal claims against a developer. One is a statute of limitations, 3 years, and then 2, those outside limits with the statutes of repose. I want to talk briefly about the kinds of claims that can be brought against developers for defects. And although we don't really mention it specifically in the PowerPoint, you know, the most obvious one is for negligence. That can be the most common one, and that's 3 years. For defective design, construction, etc. But also, it's common to bring claims for breach of fiduciary duty and breaches of warranty. The fiduciary duty one is interesting, and that claim against developers, it arises from the fact that when the condominium is created, the first trustee of your condominium trust or the manager of your association is going to be the developer. And it used to be that oftentimes it was the person who was the manager of the corporation for the developer. Now, mostly what we see is that the development company itself is the initial trustee or the initial manager of the board. But the point is this: when the condominium is created and the initial manager or trustee is appointed, and it's the developer, that person or entity has a fiduciary duty to the condominium association. And oftentimes that fiduciary duty can create a conflict of interest where the interests of the condominium developer are at odds with the interests of the condominium. For example, if the developer knows that there is a construction defect, let's say leaky windows, and doesn't do anything about it while it's the initial trustee or manager of the board for the condominium association, after the transition, you could have a claim against the developer for breach of that fiduciary duty. And we've done that, and that is an interesting claim because at the beginning of the condominium, the developer wears two hats. One is the developer and one is the board member. Next, though, is also the warranty claims. Oftentimes, we get calls from board members or unit owners, sometimes homeowners, not in condominiums, and they say, well, you know, the developer gave me a 1-year warranty and a written warranty, and it's been a year and a half. Does that mean I have no claim? And the answer is no. While express warranties are enforceable, and they can be fairly broad, that's not the end of it. I see there's a typo in my slide here under express warranty. The point is this: if there's a 1-year express warranty, you can bring a claim, of course, within that 1 year. But also, though, this under the law, there is an implied warranty that is enforceable, and the time limit is the same as the negligence claim. It's basically another way, oftentimes, of stating the same claim under a different legal theory. Under an implied warranty of habitability, you know, I've got an example for you. I had a case in which the developer, there was a claim against the developer because a septic system was defective. It didn't work. It collapsed and caused a lot of problems in a large condominium. Well, that was a negligence claim against the developer. But there is another case I've had in which there was no negligence. There was nothing defective about the septic system, but it was the wrong septic system. It wasn't large enough. That was a claim against that developer for a breach of implied warranty of habitability, because the condominium wasn't habitable because it was not serviced by a large enough septic system. So in any event, that's just an example of how implied warranty of habitability can differ from a negligence claim. When, again, you know, litigation is a last resort because of the time and expense involved. But, you know, Jen and I are litigators, and it's not unusual for us to have to file a lawsuit and go to court over construction defects issues. When you're making that consideration, it's important to be strategic in your approach. You have to act quickly because of the reasons I mentioned. You have to have realistic expectations. You know, it's not fair. You bought a condominium, a brand new condominium unit, you're a responsible person, you get on the board of the condominium association, and now you're dealing with an issue with the defect to one of the common areas, like leaky windows or roof issues. There are all kinds of problems. It's not exactly the most pleasant thing to deal with, but you have to deal with it. And you have to have realistic expectations. But what I mean by that is, even though it's not fair, and it's not, it's difficult and it's unusual to be made 100% whole when there is a condominium, when there is a construction defect. In other words, you may not recover everything. It's highly unlikely, if the case goes to court, for example, that you're going to recover all your attorney's fees and all the costs to get the defect remedied. So you have to have realistic expectations. And next, look for leverage. And what do we mean by that? We mean look for leverage to try to get the defects fixed so that you don't have to go to court. Or if you do have to go to court, you're still looking for leverage to try to get a settlement, to try to get payment, to have the defects corrected, or even still possibly have the developer itself fix the problems. Litigation is expensive and it's unpredictable. Most cases do settle, that's for sure. But you have to be ready to go to trial. Bluffing about litigation or saying, well, let's just file the lawsuit, and if the developer doesn't buckle under, then we'll just withdraw the lawsuit. That's not so easy. And that's a question I do get not infrequently. Can't we just file the lawsuit and walk away? You can. It's just not as easy as you might think, because once the lawsuit is underway, neither side is in complete control of what happens in the lawsuit. But most cases eventually do settle for construction defects. And typically a resolution involves one or more of the following: payment of money to the condominium association to fix the problem, corrective work, and you'll note that we have a parenthetical, must be careful on the work. You know, one question is, do you want the developer who is responsible for the defect to be the person in charge of fixing the problem? And so that can be an issue. Or it can be a combination of payment of some money to the association and some corrective work. The goal is to achieve the best net result, the best net result, because as I said, the idea of being made whole, it does happen, but more often than not, the net result is that pursuing a claim for construction defects does typically end up costing the association something. Traps for the unwary. One, you know, it's often the case where we want to, just by, you know, human nature, you want to go after every entity or person who's responsible. You could sue every contractor, every subcontractor who worked on the job. But oftentimes what we recommend is if there's going to be a lawsuit, you really only have to file claims against the developer, because the developer ultimately is responsible for everything. In turn, sometimes the developer does then bring in the contractors and the subcontractors into the lawsuit, but you're not required to do that. The next point is an important one. Oftentimes, as we've mentioned several times, the developer has no assets. It's a single purpose entity. It was created to build the condominium and sell units. Maybe it has some units left to sell, maybe it doesn't. And the question is, you know, is there any money to go after in a lawsuit? And typically the answer is yes, because the developer will have insurance to cover claims for construction defects. Not 100% of the time, but almost all the time, they will have insurance. The next point is, when you're thinking about all of the costs that you might incur as a condominium association, it might be tempting to enter into a contingent fee arrangement with a law firm. We generally suggest that might not be the greatest idea, because you want everybody to be motivated to resolve the matter as quickly as possible. Next is a political unrest. Political unrest meaning unrest within the condominium among the unit owners. The problem is when a lawsuit is filed, it can be difficult to sell units. It can be. And you know, I had a case in Worcester where it was a rehabbed industrial building, 100 units, and the developer discovered that there was contamination from old industrial waste on the site and decided to sell all the units and get out of Dodge. Well, obviously a lawsuit had to be filed, because that was the only way to bring the developer back And it took 3 years of litigation until finally the developer agreed to pay for all the cleanup, pay all the attorney's fees. But during that 3 years, no one could sell a unit. And so you have to be prepared for that. You have to be prepared for people being upset and dealing with the reality of that. In a lot of our lawsuits, buying and selling units is not a problem. It just depends on the degree of the defect and how serious it is. But in most cases, it tends not to be a problem. All right, Jen, you're up with document review.
It helped me to unmute. I see the time, and thank you all for hanging in with us. I'm going to jump a little bit ahead on this just to give you a broad overview. I know this is a dry topic. And again, if anybody would like a copy of the webinar, please reach out. We'll be happy to provide it. We'll also send around a checklist to everyone who's participating. I don't know if everybody wants a copy of the webinar too, so just let us know. With that, as I touched upon earlier, it's so important to review your documents to know what, hopefully unit owners will have taken a look or have been advised of what the provisions were generally before they even bought. But before transition, leading up to transition, it's so important to look at the documents, look at the phasing provisions. What do the phasing provisions provide? How long does the developer have to add or withdraw land from the condominium? What are the requirements? How in Rhode Island, or I'm sorry, in Massachusetts, there are no provisions that prohibit the amount of time that the developer has to add new phases in. So the associations governing documents will control, again, subject to what we talked about earlier with the development rights. New Hampshire, the phasing limits are for convertible land, 5 years, for expandable land, 7 years, and for contractable condominium, that means withdrawing land, that's 7 years. So in Rhode Island, to any development rights to add or withdraw land, they have to be defined in the time limit. There is no specific statutory, number of years in Rhode Island, but there is a restriction that states that there has to be something in the declaration itself. I'm sorry, Tom, I know you're going to get into phasing, so I'm going to just jump right into, the other provisions so that you can go forward. The other provisions you're going to want to look for in the documents are poison pill provisions. These are the anti-litigation provisions that state if you want to, prior to suing the developer, you have to give them notice, copy of the budget, proposed complaint. These are all issues that the Massachusetts courts are, they're coming down on the side of the associations more and more on these provisions. Most associations, the documents contain an 80% unit owner vote requirement. This is, requiring disclosure, assessment requirements. There was just a recent case that was handled by our office that declared these types of provisions to be unenforceable. Also look to mediation and arbitration provisions, and courts, if there are arbitration provisions, are going to be inclined to push for that because it just helps them keep things out of the court, keeps the cases, helps the court processes move along faster if the parties are held to these arbitration provisions. So make sure to look at those. The other, New Hampshire, Mass, and Rhode Island, all the condo acts are consumer protection statutes, and any developer favored enforcement, provisions are likely going to be deemed unenforceable. also look towards, are there illegal provisions in the documents? Sometimes even now we'll see provisions that restrict children from using certain amenities. Those are not allowed, so don't do that. Anything else that was subject to the association to potential liability? Is there anything potentially discriminatory? Is there any provisions that any easement provisions? Are there any license provisions? Look to these issues, and they might not be obvious in the document itself. That's why you have to go and look. This is why the attorney is important. I know everybody hates attorneys, but this is why they come into play here. I look at rental restrictions, right of first refusal. Sometimes a developer will have a neighboring property that was also under development, completely separate in terms of its legal existence, but they'll have a shared easement and they'll have shared amenities. Make sure you understand what those are, so that to avoid conflict and dispute. Sometimes, there's leasehold interests a lot of time, especially in Boston still, there are leasehold condominiums. What that means is that another entity owns the land and the condominium exists pursuant to, it's a leasehold. The building itself and the units, building is leased, and there are additional, a lot of times there are transfer provisions imposed. So these are all things that you're going, it's so important to look at before the transition, at the transition, and while sometimes they require the developer's consent to amend, this is try to accomplish these issues as part of your overall negotiations with the developer. Don't do things piecemeal. If there are issues, try to get the developer, if you get the developer to the table to resolve one thing, try to get everything resolved at the same time. It's so important. Knowledge is key here. It's rather than, I know sometimes you don't want to know the information, but you're much better off in the long run by having a better understanding of what you're inheriting. And with that, I'm going to turn it over to Tom to wrap up about phasing.
Thanks, Jen. And I promise not to talk too long about phasing. I could go on literally for hours about the phasing issues, but I'll give a broad overview, and then we do have some questions I see in the chat, and we'll answer your questions. But here goes about phasing. Look, this is just a broad strokes here. This is the thing about phasing. It's important to know when the transition occurs, whether the developer is done, right? So number one, is the developer done? Number two, does the developer have more time? Even though the developer's attorney typically is the person who writes the condominium documents, it is not unusual for a developer to run out of time. And what that means in Massachusetts and Rhode Island is there's a time limit built into the condominium documents. It's required in Rhode Island. Massachusetts, not required. So if there's no time limit in the condo docs, that means the developer can build units as long as that person wants to do so. In New Hampshire, there are statutory limitations. It's done, the limits are by statute. Here's the point. It does happen where a board contacts us at the transition. We take a look at the condominium documents and find out that the developer's time has run out. And either the developer doesn't know it, or the developer tries to take maneuvers to extend the development rights that are not lawful. And this can happen even though there's a lot of condominium left to build. And we talked before about getting leverage, trying to find leverage to exert against the developer to bring the developer to the table to deal with problems. Nothing will bring a developer to the table more quickly and with more enthusiasm than finding out that the developer has run out of time. on building units when there are still units to be built. I've actually have 3 lawsuits right now on this issue where there are disputes over whether the developer still has rights to build or not build. But for the most part, in those cases, the developer has an uphill battle. Most of those cases do settle. And the good news for the condominium, these are some of the statutory provisions, by the way, that I'm not going to take you through the detail of it. In Massachusetts and in Rhode Island and in New Hampshire, the association can voluntarily increase the amount of time the developer has to build units. Why would you do that? Well, the point that I was about to make is that developers will pay substantial sums of money for the to get the right to finish the condominium, because they're heavily invested already in the project and there's a lot of money for the developer yet to be made. I had a small condominium of 15 units a couple of years ago, a client where the development rights ran out. The developer still had 6 units to build. The developer paid hundreds of thousands of dollars to the condominium association to earn back the right to finish the condominium. For larger condominiums, it can be millions of dollars. Those development rights are can be worth millions of dollars. It's oftentimes argued, well, that's a windfall for the association. They shouldn't get that money because, you know, it's just a windfall. They didn't expect it. They didn't earn it. And I think that's not true, because when people buy condominium, when they buy units and there is a deadline for completing the units, completing the construction, that's what you bought. That's what you bought. So let's say it's a 7-year deadline. You bought a condominium unit with the expectation that construction is going to be done in 7 years. So it's not a windfall. You're entitled as an association, where the developer's time runs out, you're entitled to sell those development rights back to the original declarant or find a new one. And that can be an exciting time for a condominium association. It can also be if there is a dispute and a fight, those can be long lawsuits and you know, and the board has to be ready, and the association has to be ready to dig in for the fight. But oftentimes they do settle, and with the association receiving a substantial payment in exchange for releasing those development rights. So that is just sort of the really broad overview about phasing rights and development rights, and it's an exciting issue. I enjoy confronting those issues when they appear, and like I said, it can be an exciting time for a condominium association. So that concludes the presentation. Jen, I see we have some questions in the chat room. The first one is it possible to get a copy of this webinar? The answer is yes. Just reach out to us by email. We will also send you a copy of our checklist, which is just sort of a shortened form that covers just about everything we talked about today. And let's see, the next question. The HOA is organized as a business trust, a pass-through entity that is appropriate to securing investors and completing the project. Would it be advisable to incorporate as a nonprofit corporation as a better shield to contract and tort liability to association members and the HOA's directors and officers? So go ahead, Jen. That's more along the lines of what you were talking about. It sounds like that is a question coming from the developer side. Do you have it on your screen, Jen?
Yeah, so I mean, without looking at the documents, it does say, assuming this is from a question from a developer related entity, so example that the association is being run, so XYZ Incorporated, and it's and then a realty trust is set up as the trustee to declare related trustee, we've seen that. In terms of the association, generally the association is in a nonprofit organization of unit owners, and that is how going one step further down the line, we talked about 93A liability against the developer because they're engaged in business, specifically the construction and sale of condominium units. The association, in contrast, is generally a nonprofit entity that's a group of volunteer members who are engaged in the operation and management of an association for no remuneration or profit. So in terms of would it be advisable to set up to incorporate as a nonprofit, like I said, I'm a little confused.
Yeah, I guess I misread that too. It is not from I was wrong. This question is not from the developer perspective. The question just is generally, is it better to set up an HOA as a nonprofit? And the answer is yes, and they almost always are. And also, it's good to know that the directors and officers are almost universally, in all the condo docs, they are indemnified from liability for actions they take in connection with their role as members of the board.
Yeah, I would just be a little nervous about that 93A liability if they're engaged in profit. That would be a red flag for me. If I was setting up the association, I would invariably set it up as a nonprofit. And it just, I'm not sure why it would be set up as a profit unless it's, as a, like I said, a realty trust as part of the developer, and it's the original trustee. But generally, as far as I'm, I can think of maybe 2 or 3 in the 17, 18 years I've been doing this, that it's been a business trust set up, but it's so rare to do it that way. And it's preferable to establish it as a nonprofit association. It, like I said, it's a group of volunteer members who are, this is private in nature, outside of the scope of business. And 93A liabilities is quite significant if an entity is engaged in trade or commerce, and for a volunteer member or volunteer board who's not savvy, there's so much risks and potential liability there that I would want to avoid that.
All right, the next question is there a law regulating if the developer must pay condo fees per unit themselves, or if the additional fees can be collected when a unit is sold? Boy, that's a great question, and it's one we run into frequently. And the answer is no. I'm not aware of any specific law that says the developer has to pay condo fees per unit. This is a topic of some dispute in a couple of cases I have ongoing right now. Our position is that when a condominium is created and the records are recorded with the Registry of Deeds, that creates the units. At that point, the developer, as the owner of those units, has to pay fees. Now, there are exceptions to that, and that's a very general statement to make. However, some developers try to squirm around that by not paying fees at all. They just don't, and they say, well, the unit wasn't sold. But the point really isn't whether the unit is sold. The point is, when is a unit a unit? And the answer is not necessarily when the unit is built. When the condominium is created, all the condominium documents that are filed are going to have a schedule of the percentage interests of all the units, and that has to add up to 100%. So if it's a 10-unit condominium and all the units are submitted to the condominium at the very beginning, those 10 units, there are fees owed on those units. And if they're not sold, then the developer should pay. That's our position.
But
A
here's the flip.
developer can work around that by not in a phase condominium. They can wait until they create the condominium by recording the phasing amendment with the Registry of Deeds. They can wait until the condominium unit's done. They can do that. So there are ways for a developer to legitimately avoid paying condo fees, but oftentimes they don't. And it's not uncommon, for example, for a developer to say, well, I started paying condominium fees when I got the certificate of occupancy for the unit. There's no law to support that position. So as a general rule, we subscribe to the theory that the condominium unit is created when the documents are submitted to the Registry of Deeds. And at that point, the developer has to start paying.
And the other thing to think about, though, is that when the developer is in control, they'll issue what's called the 6G certificate. And basically, that's a statement of common expenses that are due at the time of sale. And what happens is that the developer is in control. The developer will sign these documents, and it will allow the next owner not to have to, it doesn't bind the next owner for all these past due fees. So if they're not being collected from the developer before the developer leaves, it's going to be tough to recover. And then, as far as the the additional fees when a unit is sold, this is another thing to look at. Sometimes the documents will require that 2 months upon transfer, 2 months be put into reserve. So again, this goes to the fiduciary duty aspect as a developer collecting and properly assessing and collecting common expenses. I know that a document review and looking at all these financials seems overwhelming, but I promise you, it's as someone who's not very good at math or accounting, it's relatively simple by just looking at the date a unit was, units were phased in, looking at comparing that with the list of ledgers, and that a ledger is basically just a list of charges and payments for each unit. It's easy to figure out when condo fees were first paid and versus when they should have been paid.
And if it's a large condominium, I've got one right now, it's over 300 units. We hired an accountant to go through it, and the developers agreed to pay over $100,000 in fees in that case. So, if it's a large condominium, you might need outside help. The next, a number of people are asking about whether the PowerPoint and the checklist will both be available, and the answer is yes. And to those who've asked, we'll definitely send it to you. Next question is, if the homeowners populate the board and replace the officers, do the liabilities of the developer entity survive the transfer of control? You bet it does survive. The developer is not off the hook merely because it is no longer on the board. So that's just not even a question. So yes, the developer's obligations survive the conversion.
What expectations should the condo board have relative to asking the developer to provide warranties, building plans, site plans, original condo docs in electronic format? You could certainly ask, but fortunately, these many times the condo documents are going to be available for free, or for the cost of the charge by the registry in the applicable county where the association is located. Building plans, site plans, those will do everything. First of all, everything should be turned over by the developer or by the association's management company while it's under developer control. Those are all books and records of the association and should be turned over, but it's always good to also obtain these documents independent if there's any doubt. And so there's the way to do that is to go through the registry. You can also do what's called a public records request under the Freedom of Information Act to local city, town. They might charge a fee for copying and to research these documents. But those are also available through the city and town. That way you can get permitting, any outstanding issues, make sure all the permits are signed off on, notices, citations, all of that should be available through the local city or town's office through a public records request. And in what I basically under the request, the city or town responding has 10 days to provide the documents or to respond that they don't exist or that they're subject to some sort of privilege, which in this specific instance, there's very few privileges that would prevent a city or town from producing the documents.
Next question, can we amend the deed or trust with sufficient votes prior to the transition from the developer? You sure can. And I think the right way to do that would be to look at your condominium docs, find out the process for calling a special meeting and making sure you go through the procedures that are in your condominium docs for proposing and then voting on an amendment to the deed or trust.
Can a board be formed if there are only 4 individuals volunteering, but the master deed states the minimum of 5? So it'd be the declaration of trust that you'd be looking at. And sometimes the declaration of trust states that it's got to be a minimum of, number or other number as determined by the association. And so the association can vote to, change the number of trustees on a board. But if only 4 trustees are on a board and there's a 5 required currently, you have a vacancy on the board. And the reason why most associations have an odd number is to prevent that standstill. When there's 2 and 2 against each other, there's got to be that deciding vote. And so if 5 are necessary, I would look to the documents, see what it calls for filling a vacancy. Sometimes it's by appointment, sometimes it's a special election. But if your documents currently require 5 and you don't think you can get the votes to amend to change that number, follow the provisions in your documents for filling a vacancy.
Okay, the next question is, we've been asking for defects to be fixed for a year now. The developer is either refusing to fix or dragging their feet. Should we act more formally to claim construction defects prior to the sale of the last unit? And the answer is yes, absolutely, 100%, particularly in light of the fact that the clock is ticking on those statutes of limitation, the statute of repose. And our advice would be to make a more formal claim. And, and really what we would advise is that you contact an attorney to get some advice on the best way to do that.
So when the developer is a trustee of the HOA, does he or she need to hold annual meetings or send out HOA financials? Look to the documents. If that's what this calls for, they are bound by those documents just as much as the successor board of unit owners. If they're required, if the documents call for annual meetings to be held, then he or she is required to hold annual meetings, similar to the financial statements under 183A section 6. I'm sorry, I'm just to be able to quote these versions, I'm such a numbers. But it requires that the budget, basically those condo fees that we talked about earlier, those are to be assessed pursuant to a budget that's to be adopted at least annually. So they should be having an annual meeting to adopt that operating budget by which common expenses, condo fees are assessed.
So next is a follow-up from Rick on the prior question about trying to get the developer to fix defects. We've been trying for over a year now. And the question is, how do we formally raise or document the issue of construction defects now so that they don't get fixed later? We have a record of the issues being raised, and that includes unit defects and common area defects. The fact is, Rick, what I would tell you is that these are very situation specific kinds of questions. And so there's an array of different things that you can do to make your points with the developer, and you should talk to an attorney because it really depends on what's happened in the past and what's going on now. Keep in mind that it's not unusual for the next step to be a lawyer letter to the developer making the demand. That is typical. But keep in mind that making the demand does not stop the clock running on the statute of limitations or the statute of repose. Those clocks are only stopped with the statute of limitations by a formal tolling agreement, which you would have to have with the developer, and you can toll the 3 years. But the statute of repose, you can't toll it. So the clock just keeps running on that. So until a lawsuit is filed. So just keep that in mind as you move forward. Jen, you want to?
So for example, the documents don't have an audit clause. So under the statute, the associate, first of all, under, again, I'm going to quote the statute, God, 183A section 10, there's a specific set of documents that every association is required to maintain. Its financials, its the books, books and records of the association. So those are contracts, those are the financials, those are, there's a myriad of documents that form the records of the association under 183A section 10. Any unit owner can make a request for those documents. They're supposed to be held for at least 7 years. And then depending on the size of the association, there can also be audit or financial review of documents requested as well. It really varies by the size of the association. But as far as the financials, any unit owner can request copies of those.
Next is from a fairly new manager, Eric. What can I do to better prepare myself during a transition from developer to condo owner? So, number one, familiarize yourself with the condo docs. Absolutely. You should have them on file anyway, but familiarize yourself with the condominium documents. Try to learn more about the condominium statute in the state that you're located in. And even though I suppose it sounds self-serving, I really don't mean it to be, call an attorney and start talking and just go through it. And what kinds of things should be looking for. Here are some things I found with this particular condominium. What do you think? And that's your safest bet. Rely on professionals who are in the business. Not just attorneys, but also, of course, there's engineers and other professionals that you should reach out to as you go along and as issues arise. Next,
Just jump in though on that.
Yeah.
Even if and we say that regardless of what side you're on, if you're representing if you're a manager for the developer or for the board, there's guidance, and if we were representing the developer, we would encourage the property manager to go take the initiative and be proactive, have a transition study done ahead of time, avoid all of the the potential pitfalls that could come up if these issues aren't addressed. It's as much as in the interest of the developer as it is in the association to avoid litigation.
Next is a question about the checklist and the materials. Yes, this presentation on PowerPoint will be available. The next substantive question is, during developer control, is it common for developers to pay HOA fees for sold units? Well, I'll take that to mean the question is it common for developers to pay the fees before the units are sold? And the answer is yes, that is common. And then what happens once the unit is sold? Of course, then it's the new unit owner who's responsible for paying the fees. But prior to the sale of a unit, it's not unusual for the developer to pay fees. As litigators, Jen and I know, it's also not uncommon for developers to try to avoid paying those fees as well. So, but there are responsible developers out there who pay their condo fees on their unsold units from the start and do it the right way, and that is not unheard of.
And just to that point, sometimes the developers, especially if there's going to be an assessment coming up, they might try to entice buyers again by putting that money up in front. It varies by each situation is different. And so we really can't say blanket, answer to that specific question. But, with that in mind, take this all with a grain of salt, because every association is a bit different. There's no specific protocol in place that we can say this is what you do in every situation. But that's why, you have to build your team. You have to rely on the people around you. This is not a one man or woman, exercise here. This is a team effort. And you're going to have to be surrounded by people who you trust. These are going to be people that you talk to if during transition, for as long, both before and after. It can be a period of months. If there's litigation, it can be a period of years. You have to rely on these people, and you have to trust them and feel supported in the process.
And I would say, sort of as very general rules, though, on the developer side, if we're representing a developer going through a transition, I think we would always recommend to the developer that he or she plan in advance, notify the unit owners in advance that the transition is coming, get all the ducks in a row to make it a smooth transition. Not all developers do that. It's a pretty broad array of what happens in a transition. Some developers are excellent and walking the unit owners through the transition and make sure everything's done just right. But I've also gotten calls, and I know Jen has too, from unit owners who say, well, the developer's gone. What do we do now? Nobody's told us anything. And that can happen. So that would always be, I think, our advice to the developer. On the condominium side, it is very typical for us to recommend to the new board that is controlled by the unit owners to hire an engineer to do a transition study. And that is done for two reasons. Number one, it's a reserve study. The engineer will look at your buildings and will give you an opinion on how much you should plan for in the future to have in reserve to make for maintenance and repairs. For example, on your roofs, that's the most common one. You want to know the lifespan of the roof, how much money is projected that you're going to need in the future to pay for it, how much time you have to save, how much you should be putting aside. The second purpose of that transition study by an engineer is to decide, or not decide, but is to determine by a professional, by an engineer, whether there are construction defects. So I think that would be pretty standard for just about every transition, don't you think, Jen?
Yeah, I think it makes a lot of sense for either. And I encourage my developer, associated clients, that be proactive. The more you can get ahead of the issues and address them before that, the less likely you will be in litigation. We can't prevent it entirely, but as litigators, the more you do this, the more you can try to encourage your clients to avoid litigation. And sometimes it's unavoidable, but it's the goal here is to, if you can't, to make it as seamless as possible. Obviously there's going to be hiccups, there's going to be bumps in the road, but the goal really is to try to do everything possible to avoid a full protracted litigation if possible.
All right, it looks like we've run out of questions. Thank you all.
Thank you for bearing with us.
Logging in, very much appreciate us. You can reach out to us with follow-up questions at any time. And for those who have asked, we certainly will provide you with the PowerPoint and with our checklist. And we hope that we haven't thrown too much information at you in a brief hour and a half. That's a lot, but it's important. Thank you all.
Thank you.